Evan Rosen here, reporting back after just completing a hearing via Zoom in Palm Beach County. The hearing was in Palm Beach County. I was not in the age of COVID. One of the great silver linings is that for uniform motion calendar, simple non-evidentiary hearings, and even now some evidentiary hearings, I don't have to drive to court. I don't have to get up at 5 in the morning and get ready and get to Palm Beach, which is an hour drive for me, and beat traffic and get there for a 9:30 hearing and then drive back. So for a long time, when I come back from court, I would always be very excited about different things that I saw. There's a reason why there are so many courtroom TV shows and movies, because there's a lot of courtroom drama. And I see it almost every single time I'm in court. And pre-COVID, it was a regular thing for me to come back from court and share with the team what happened. I can see certain team members' faces the second I walk in, looking down the hallway, ready for the report, what happened. Because there was often something that happened that was a little outrageous, either something really good that a lawyer did, or some great result, some justice that was served, or something outrageous where a lawyer did something totally improper. There was almost always something. Today, I was one of the first ones to get heard, and it was a simple issue. The drama was minimal, but I'll relay what I saw really quickly. There was a case involving an injured child who had a respiratory illness, and there was a lawsuit. I don't know the underlying basis of the suit, but there was a discovery hearing today where someone was seeking medical records for the entire child's life, a 7-year-old child, and they sustained a respiratory illness. I'm going to go out on a limb here and maybe guess that this is something COVID related, but they sustained the injury certainly within a reasonable time ago, and the plaintiff's lawyer saying, look, I don't have an objection to them getting records, but it should only be related to respiratory illnesses and not his entire medical chart for 7 years. And the court got that correct and agreed and limited the subpoena to protect the client's, the injured person's records that are not relevant. Another interesting case involving a slip and fall where someone was seeking all repair records for a building and surrounding the entire premises, even though there was a slip and fall in the parking lot. Why would you need records for the entire building when really all you need, inspection reports at least, when is what they were seeking when the fall was in the parking lot? So that the court got right too. And then my hearing came up, and the bank, it's a foreclosure case. The bank is seeking to default an unknown spouse of my client. My client's not married. There are no unknown spouses, but this is fairly common. Banks name unknown parties, unknown tenants. And it was noticed for hearing. And so I appeared. I have a client to represent, even though it should not have involved my client in any way, shape, or form today. There was a couple things that I was concerned about that I've seen in the past where judges can enter orders or schedule things, even though under the due process, the only thing that should be heard that day is what's noticed for hearing, which again was a motion for judicial default against an unknown spouse of my client. So in an abundance of caution, I'm ethically obligated to zealously represent my client. The hearing was coordinated with my office. They noticed it for hearing, and I appeared. And especially in light of, I would have probably appeared even pre-COVID live, or I had an associate appear. But here via Zoom, of course, all the more reason it's that much easier. So I appeared, and it was interesting. Right out of the gate, the judge's tone was dismissive, insinuating, "Why are you here? This is just a motion for default." Your Honor, I have no objection, but this was noticed for hearing, and I'm here to serve my client and appear in a duly noticed hearing in my client's case. So apparently a lot of lawyers don't do that, and that's the takeaway that I got, that a lot of lawyers will not appear to things that don't directly involve their client in a particular matter. I've never subscribed to that theory. I understand why some lawyers do it. It's something I think about from time to time in certain instances, but I can't recall ever not appearing. Now, if there's an opposing counsel that I really respect and have a good history with of trust, then that might be different, where there's an agreement in advance that, hey, I'm only going to seek this agreed order, and I'll only convey to the court that you agree and have no objection. That I've done on rare occasion, but it has to be someone that I have an established track record with. So anyway, I'll keep filling you in. I hope you find this enjoyable and look forward to sharing significantly more interesting stories than this first one. not the best start to this video log series, but I hope you enjoy it nonetheless. Have a great day, everyone.